In my 32 years sitting on this bench, I have witnessed just about everything a county courtroom can offer. I have watched men arrive in this room wearing their authority the way they wear their uniforms, as something so habitual they have stopped noticing it as something they put on. I have watched institutional familiarity function as a defense strategy. I have watched small jurisdictions protect themselves from accountability by simply assuming that the people in the room all understand how things work here. But never, not once in 3 decades, did I sit in this chair and watch a man tell me, in response to a question about 47 vulnerable patients whose medications had been diverted for 3 years, that the operational decisions of his department were not subject to examination from this bench, and then watch him decide, before this morning was over, to reach up and unpin his own badge and set it on the table in front of him. That morning arrived on a gray Thursday in October, and what happened in this room before noon became the thing people in this county talked about for years when they tried to explain what accountability actually looks like when it finally arrives. If you believe that a badge is a public trust and not a personal instrument, you will want to hear every word of what I am about to share. And if you want to watch 22 years of unopposed authority encounter the one question it could not answer, go ahead and hit that subscribe button right now, because you are in exactly the right place. It began as any ordinary Thursday would. I walked into my courtroom at 8:55 a.m. The note card my grandmother gave me the day I was sworn in tucked in the leather folder under my arm. The gallery was fuller than any county contempt matter had a right to be. People standing along the back wall. My clerk, Margaret, was standing at the station rather than seated, which she never does. She looked at me when I came in and said quietly, "Special matter, Sheriff Harlan." I sat down. I opened my docket. I read the name twice. Sheriff Dale Harlan, 22 years wearing the star, 3 consecutive re-election campaigns, each of them uncontested, the longest-serving law enforcement officer in the county's recorded history. His face had appeared on roadside billboards between election cycles for the better part of a decade. The same photograph each time, the same phrase underneath it. Keeping Mercer County safe, the Harlan way. He was seated at the defense table in a pressed khaki uniform, his badge catching the fluorescent courtroom light with every small movement. Beside him sat Gerald Fitch, the kind of county attorney whose client list reads like the membership roster of every civic organization in Mercer, who has spent 20 years practicing in small jurisdictions and has learned that institutional familiarity is the most reliable defense available when your client is the institution. At the prosecution table, Elena Marsh, 41, 13 years in the county prosecutor's office, organized in the specific way of someone who has been preparing for a long time for a proceeding that previous attempts had not made possible. She had filed a complaint against the sheriff's department 4 years earlier for records mishandling. It had gone nowhere. She had not forgotten what she learned from watching it go nowhere. In the gallery's front row, a woman in a blue cardigan with reading glasses pushed to the top of her head and a folder resting in her lap that she had not opened, because everything in it had already been entered into evidence. Her husband sat beside her, a retired school teacher with his hands folded. She was not performing distress. She was the specific stillness of someone who has spent months being told her documentation was insufficient and has spent the intervening time making that position impossible to maintain. I read the room. The docket entry said contempt and obstruction. The room said something considerably larger than that. Elena Marsh presented the background with the precision of someone who has spent 13 years learning that the most effective advocacy is the kind that requires the fewest words to make its point. Irreversible. The woman in the front row was named Ruth Calhoun. She was 58 years old and had operated Calhoun Family Pharmacy on Main Street in Mercer for 26 years, the only independent pharmacy within 40 miles of the county's rural communities. What she noticed was this: prescription medications were being diverted from 6 care facilities before reaching the patients for whom they had been prescribed. She had spent 4 months documenting the pattern: medication logs, delivery records, billing discrepancies. Two facilities where the same shipment appeared on the intake manifest and the patient administration records simultaneously, despite a documented 2-day gap between the dates. 4 months, because she understood that what she was about to bring forward would not be believed unless it was impossible to dispute. She filed that documentation through proper channels with the Mercer County Sheriff's Department. Sheriff Harlan received it personally. The complaint was reviewed, classified as lacking actionable specificity, and filed. 2 unannounced health code inspections of her pharmacy followed, both finding nothing actionable. A formal letter arrived from the department's legal office advising her that further independent inquiry into care facility records could be characterized as unauthorized access to protected health information. Ruth did not stop. She continued building her documentation in parallel, identified Deputy Roy Sims as the source of the diversion, took her expanded package to the county prosecutor's office, and bypassed the sheriff's department entirely. Deputy Sims was arrested. The investigation surfaced Harlan's role, and the 47 patients whose medications had been diverted: dementia patients, late-stage cancer patients, adults in a group home for persons with severe cognitive disabilities, were finally given names in a formal record. Elena placed 2 documents side by side on the evidence table. The first was Ruth Calhoun's original complaint intake record, the version Ruth had retained a copy of the day she filed it, dated and time-stamped, bearing the initials of the receiving deputy. The second was the version the Sheriff's Department had produced in response to the prosecutor's subpoena. They differed in 3 material ways. The forensic document examiner's analysis was entered into evidence. The alterations were not administrative corrections. 3 specific entries had been removed from the original intake log, entries that established that Ruth's complaint had been reviewed by the receiving deputy, flagged as presenting credible indicators warranting further inquiry, and then personally reclassified by Sheriff Harlan as lacking actionable specificity within 48 hours of receiving the deputy's assessment. The original entries existed in a backup file that the department's IT system had retained automatically, a file that had not been identified as subject to alteration, because whoever had altered the primary record had not known it existed. Beyond the records, the timeline of the 2 unannounced health code inspections aligned to within days of each documented escalation in Ruth's independent investigation. And the letter from the department's legal office had been drafted by an attorney who was simultaneously retained by one of the 6 care facility operators under Ruth's scrutiny. Gerald Fitch rose. He presented the institutional familiarity defense, administrative corrections, unrelated inspections triggered by a separate anonymous tip, a routine statutory notification from the legal office. He delivered it with the practiced ease of someone who has made this kind of argument in this county before and has seen it work. I let him finish every word. Then I looked at Sheriff Harlan and asked him the question he was not prepared for. Sheriff Harlan, I want to ask you a direct question. In the 3 months following the filing of Ruth Calhoun's complaint, the 3 months during which 47 patients across 6 facilities were continuing to receive diverted or substitute medications, what specific action did your department take on that complaint? His attorney began to rise. I raised one hand. He sat down. Harlan said the complaint had been reviewed, found to be lacking actionable specificity, and appropriately filed pending the development of additional corroborating information. I said the complaint included 4 months of medication logs, delivery records, and billing discrepancy documentation from 6 separate facilities. I want to ask you to tell this court specifically what additional corroborating information your department required before the medications of those 47 patients warranted an inquiry. Harlan's composure did not break. It shifted, the specific visible shift of someone who has recognized that the institutional familiarity he arrived expecting is not the atmosphere in this room. He said, Your Honor, the operational determinations of the Sheriff's Department regarding complaint prioritization are within the department's discretionary authority. I would respectfully suggest that second-guessing those determinations from this bench exceeds the appropriate scope of a contempt and obstruction proceeding. The room went very still. I looked at him for a long moment. Then I said, "Sheriff Harlan, this court has noted that position. It will be addressed." I turned to Elena Marsh. "What else do you have?" Elena had considerably more. She presented the communications between Harlan and Warren Pruitt, a man who had donated to each of Harlan's 3 re-election campaigns, who held a seat on the county's Emergency Services Advisory Board through an appointment that required the sheriff's formal endorsement, and who operated 2 of the 6 care facilities whose medication records were in evidence. The communications showed a relationship that predated Ruth's complaint by several years and that continued through the period during which her complaint sat classified as lacking actionable specificity. Then the facility nurse. A nurse at one of Pruitt's facilities had raised concerns internally about medication discrepancies 14 months before Ruth filed her formal complaint. She had been told by the facility director that the matter had been discussed with the sheriff and would be handled quietly. She had been transferred to a different facility within 3 weeks of raising the concern. Then Elena presented a text message exchange between Harlan and Gerald Fitch sent 4 days after the prosecutor's subpoena was received. Fitch had written, "The intake logs are the problem. You need to get ahead of that before they pull the originals." Harlan's reply, "Already handled. She won't get traction with what's left. And as she keeps pushing, I have enough on the Calhoun woman to make her the story instead of me." At the defense table, Gerald Fitch closed his folder. He did not look at Harlan. Then the surveillance records. 6 months of surveillance generated by the Mercer County Sheriff's Department documenting Ruth Calhoun's movements, her pharmacy's supplier contacts, her communications with the state pharmacy board, her meetings with her own attorney, generated using department resources, not connected to any active criminal investigation. Ruth Calhoun had never been the subject of a criminal investigation. She had been surveilled for filing a complaint about her patient's medications. Gerald Fitch rose from his chair. He informed the court that a conflict had become apparent, specifically that his own communications had been entered into the record as evidence in a matter he was actively defending. He requested that the court allow time for Sheriff Harlan to retain new counsel. I noted the withdrawal. I did not grant a continuance. I said, "Sheriff Harlan, you have the right to represent yourself in this proceeding or to request that the court appoint counsel. What I am not prepared to do is allow the pace of this proceeding to be determined by the evidentiary developments that have arisen from your own conduct and your own attorney's communications." I looked at the record assembled in front of me and held the full picture before I named it. A complaint filed by a pharmacist who had spent 4 months building irrefutable documentation, suppressed within 48 hours of a receiving deputy flagging it as credible, a donor protected, a nurse transferred, a pharmacist surveilled for 6 months for having filed it, records altered in response to a lawful subpoena, and a text message in which the defendant had indicated his intention to use whatever he had gathered about Ruth Calhoun to redirect the focus of this proceeding away from himself. I looked at Harlan. "What I want to ask you now is not a legal question. It is the only question that has mattered in this room since this morning began. The woman with late-stage cancer whose pain medication was replaced with a non-controlled substitute for 14 months. The man in the group home who cannot speak for himself and who received a substitute sedative for 8 months. The 47 patients in your county. You wore that badge for 22 years. You were supposed to be the person they could count on. I want to ask you whether at any point in the last 3 years you thought about them." The room was completely still. Harlan looked at the bench. Then he looked at Ruth Calhoun in the front row, sitting beside her husband with the stillness of someone who has been waiting for this room to ask exactly this question for a very long time. Then he looked at his badge. It was catching the fluorescent light, the same way it had been when he walked in that morning. The same badge, the same light, but the room around it had changed completely. He reached up. He unpinned the badge from his uniform with a single motion. He set it on the defense table in front of him with a sound that was quieter than anyone in the room expected, and he said, "I resign, effective immediately." The room did not erupt. It held the silence the way rooms hold silence when something that has needed to happen for a very long time has finally happened, and the people present are taking a moment to understand that it cannot be undone. I looked at the badge on the table for a moment. Then I said, "Sheriff Harlan, your resignation from office does not conclude these proceedings. This court's jurisdiction over the charges before it is not dependent on your title and was not granted by it. We will continue. Guilty on all counts: obstruction of justice, abuse of official authority, criminal contempt of court for the material alteration of records produced in response to a lawful subpoena, 18 months in the county correctional facility, no bail beginning immediately, full restitution to Ruth Calhoun for the documented costs arising from 6 months of unauthorized surveillance and the legal fees attributable to the department's interference with her investigation. A formal referral to the State Attorney General's office for investigation of the care facility operators connected to the diversion scheme, including Mooring Pruitt. A referral to the State Ethics Board regarding Gerald Fitch's conduct. A referral to the state legislature's Oversight Committee for a full audit of 5 years of intake and records management procedures. The audit would surface 9 additional complaints that had been administratively buried. 6 of them would be reopened. Deputy Roy Sims had been separately charged. His plea agreement included full cooperation with the prosecutor's investigation of the distribution network across 3 counties. I call Ruth Calhoun forward. She walked to the bench unhurried, carrying nothing in her hands, because the folder in her lap had already done everything it needed to do. I told her that the documentation she had built and protected and carried through 4 months of building and 5 months of being undermined was accurate, sufficient, and had now produced consequences for every person who would believe they could outlast her patience. She said, "I just needed someone to read what I brought. I keep that sentence on a note card in the top drawer of my desk, next to a photograph of my grandmother, a woman who spent 40 years as a home health aide in the county 2 seats over from this one, who used to tell her granddaughter, 'The people who can't speak for themselves need someone at the table who will.'" The cascade unfolded over the months that followed. The Attorney General's investigation produced charges against Warren Pruitt and 2 facility directors, 1 conviction, 1 plea agreement, 1 acquittal. Gerald Fitch's license was suspended for 2 years. The legislative audit surfaced 9 additional buried complaints, 6 of which were reopened. Elena Marsh was appointed deputy county prosecutor and led the care facility oversight reforms. Ruth Calhoun's pharmacy received a state recognition for public health service. The 47 patients were identified by name, their families notified, and the civil class action settlement funded enhanced medication oversight protocols across every licensed care facility in the state. Harlan served his sentence. He did not speak publicly about the morning he set his badge on the defense table. The record speaks for him, precisely and in full. The next Mercer County Sheriff was elected from among 3 candidates, none of whom ran unopposed in the highest turnout county sheriff election in 14 years. I looked at the gray October sky through the courthouse window on the morning after and called the first matter of the day, still here. The law, still here. That is the whole of it. I want to say something directly to everyone watching this. This story is not about county politics or departmental hierarchy, or which title confers which authority in a small jurisdiction. It is about something considerably simpler. What happens when a person wearing a badge for 22 years decides that a campaign donor's exposure is worth more than 47 people's medications? Ruth Calhoun spent 4 months building documentation and 5 months after filing it being surveilled, inspected, and professionally undermined by the department she had trusted to act on it. She walked into this courthouse in a blue cardigan with a folder in her lap and her husband beside her. All she needed was a room that would read what she brought. Dale Harlan told his attorney that he had enough on the Calhoun woman to make her the story instead of himself. He made that statement in a text message he sent from a phone he did not know would be in evidence before the morning was over. The question that made him set his badge on the table was not about records or procedures. It was about 47 people, some of whom could not speak for themselves, every single one of whom deserved a sheriff who thought about them. That is what this bench is for. Not for the badge or the billboard or the 22 years, for Ruth Calhoun, for the 47 patients, for every person who walks through that door carrying what they brought and needing someone to read it. Share this. Subscribe. Justice still has a pulse. It always belonged to everyone.